the demons call when they do what they do. And now I feel like taking off, find a place with a view. The pain is never gonna stop if it's controlling you. I know that time can heal it all, I just gotta get through. I just gotta get through, I just gotta get through. Cause I feel like taking off, find a place with a view. The pain is never gonna stop if it's controlling you. I know that time can heal it all, I just gotta get through. Sometimes I feel like all is lost, but I know it's not true. I wanna put up all my walls cause I'm not in the mood, but then I cut myself off from the rest of the room. I know that time can heal it all if you're patient and soon it can all be worth it, all the searching. Pain is never really permanent, but damn it hurts, man. I could feel all of the turbulence and it's concerning. I've been searching for a purpose, I hope it's worth it. This society is really trying me. Ain't no hide and seek, I hide to be far from anxiety. I need my space, I need my privacy. I need some silence, please, you're all too loud. You don't speak quietly, opinions violently thrown across every surface. It makes me nervous, it's the world honestly burning. That's all I'm learning, hope that we can make a turn and start reversing. All our minds, we put the work in, we got some work, man. I started to do, gotta get through. I started to do, gotta get through. I can hear the demons call when they do what they do. And now I feel like taking off, find a place with a view. The pain is never gonna stop if it's controlling you. I know that time can heal it all, I just gotta get through. I just gotta get through, I just gotta get through. Cause I feel like taking off, find a place with a view. The pain is never gonna stop if it's controlling you. I know that time can heal it all, I just gotta get through. I just gotta get through. Gotta get through this, life is a nuisance, tie up some loose ends. I try to be human, find a solution, my evolution. A place like this, it didn't exist, we made it like this. So you can go pick the bad or the good, got a glass half wish. I know, it's easier to hide than just to lay low. Not everyone in life has got a halo. I'm standing in the red inside a payphone. Just wanna break, no, I'm not gonna give in. Take a last shot, Michael J. Win. No, I'm not a robot, I'm in my own skin. Never get lost when thoughts pull you in. I miss the old you, we died with a purpose. All the energy around me felt nervous, scared I would pop off fast to the surface. Had to cut it off before you made me worthless. Torn apart, I've been torn and scarred. I had a given art, but now I'm thinking smart. I'm keeping up my guard, I'm hiding every card. A royal flush of left, you never know what's hard. With a back to the mat, gonna see where I'm at. I'ma fight like I'm mad, I'm a beast of the net. They can never be me, nice try, but they'll see I achieve everything while they stay salty. I started to do, gotta get through. I started to do, gotta get through. I can hear the demons call when they do what they do. And now I feel like taking off, find a place with a view. The pain is never gonna stop if it's controlling you. I know that time can heal it all, I just gotta get through. I just gotta get through, I just gotta get through. Cause I feel like taking off, find a place with a view. The pain is never gonna stop if it's controlling you.
All right, peace, everybody. Thanks for tuning in to another episode of Truth Tuesday with your host, Akeem. L here on Hindsight Radio, the information station changing the nation. I hope everybody's doing great. I'm doing wonderful. Feeling good. One second. I don't know if y'all can hear me. How's my sounds? The music too loud? Oh, let me know what you got. Man, we got a low turnout tonight. What's going on? I had more people when I did that impromptu live yesterday on. Tonight, regular show night is kind of low. Maybe they're just waiting. Usually I start around 7:10. So I'm a little early. Uh said it sounds great. Thank you. Discipleship Ministry. Thank you, Corinne. Thank you. I hope everybody's doing well. It's October the 25th. And I hope everybody's still moving forward in all of their aspirations, affirmations, all of the things that you want to accomplish that's good in your life. So December is almost here. The the ritual is here. I got to put that together. After at the end of this week, I'm going to put that together. Send out the invitation for that New Year's ritual. I got to start preparing for that. Also, I got to start preparing for my seminar on November the 12th in Las Vegas, Nevada. Come join me. Um, let's see, where is it going to be? My wife bought me this dry erase board that I haven't made use of yet. I could have just looked over there if I'd have just wrote it down like she gave me. That's what she gave it to me for. I should have done that. Now I'm pulling up the website, get the dates for you. Let's see. Seminars, webinars. It is Las Vegas Seminar 7690 South Las Vegas Boulevard, Las Vegas, Nevada 89123. I have to update that flyer because that's the Residence Inn, I believe. Residence Inn in Las Vegas. Saturday, November the 12th, 1 day seminar. It's only $149.99. I haven't had it this cheap in whenever. I haven't had a seminar this cheap ever. I made it this cheap. I know it's the end of the year. Some of you guys into your holidays, y'all need that bread. So I knocked it down. And this was put together by the group of guys that what do you mean? Out in Las Vegas that listen to me, that follow, and they wanted me out there. So I'm coming. I'm going out there. So I look forward to that. We're gonna be talking about religious nonprofit unincorporated association tax exemption, religious protection, constitution, bylaws, template protected corporation or LLC. And it's going to be a special pricing, discount pricing for premium membership for attendees. Anyone who wants to join that, me and get on that. It's good information. A lot of great things is happening. Things have picked up momentum, and it's always good to get those testimonies. So that's what's happening in November. So December, possible another seminar in Champaign, Illinois. I'm not sure yet. I gave the dates I could do it. I will let you guys know. So I got to do one in Ohio. Matter of fact, I think I'm going to do Ohio first of the year. Not sure. Put that together. I got to get contact with the people in Ohio and make that happen. So, what are we talking about this evening? Thanks again to Corinne, Steve Johnson there for my glass. I'm using it again. Taking in my spirits so I can flow. What are we talking about tonight? This Darrell Brooks trial. It's been very interesting. And at times for me hard to watch because I'm watching this guy try to use these unproven techniques throughout the years to get out of this murder trial he's on. Over and over, he's using the same techniques over and over and over. Right now, he just finished up his closing arguments, and it was terrible, to say the least. You want to kind of feel something for the dude, but when you look at the loss of life that took place because he drove through a crowd, and I can't see how you could justify that. You see a bunch of people in the street, you see people in the street on the sidewalks having a good time doing a parade, and you're driving through there over 30 miles per hour. I saw the video when he was driving. He was driving like he was on a regular street, barreling, not even braking. It's crazy. But the only reason why I'm even showing this is because I want to prove to y'all that this nonsense that you've been taught all of this time, this stuff does not work. It don't work. Too many times I get these, oh, you could do this. Even when I did the video yesterday, people came into the chat, oh, it doesn't work for criminal. There's a victim. But this, that, and the other. But then I asked the question, okay, since you think it works in some other format, in another type of case, give me the proof. Guess what? Silence. No rebuttal. See, I'm not gonna go back and forth with these idiots and try to prove what I'm saying is right. See, I know I'm right because in all the 7 years I've been doing this, going on 8, I have never seen anybody produce any proof. Not one. I haven't never seen anybody produce any proof about how they discharged anything. I haven't never seen anybody show me any proof that they use GSA bonds for anything. And I have not seen anybody show me any proof that they'd use accepted for value on anything and it ever worked. But yet, this guy here is operating off of all of these premises in this case where he drove over people, killed them, injured others. He's using these techniques, these tactics, these legal theories, because in his mind, it works. And if you sat him down and asked him, have you seen it? Have you ever seen this work for anybody before? The issue today is we've been lied to so much that we'll believe a lie before we believe the truth. People get mad at me when I tell them, hey, show me proof. That doesn't work. They get mad because I'm destroying their fantasy that they created in their mind about this stuff. And we all know people don't like their fantasies destroyed. And the most of the people that's attracted to this nonsense, they have big financial issues. They're lost, looking for an answer. They can't cope with handling things the right way, so they look for underbelly or things to try to use to get over and not have to pay bills. Let's just say he said, I want to let's just play the video so y'all can hear this stuff, man. So y'all can hear it. Okay. I'm trying to see which way I want to do it. Let's do this. Let's play this stuff. The judge is going to come in a second. That's why it's silent. Give it a second because they had his mic muted. Come on, come on. Child of God said, you don't believe that men process will work not in a particular seat. No, it won't work ever.
The record should reflect that Mr. Brooks is now present in the main courtroom. Prior to reopening following the break, I did invite him back into the courtroom, and he is here. I trust you are ready with your closing argument, sir.
I'm ready to address subject matter jurisdiction as well, too.
The request is denied.
Just for the record, I was addressing it for both courtrooms here in courtroom number, I think it's 20.
Mr. Brooks, I'm going to bring the jury out. Are you prepared to present your closing argument?
I would like for you to prove subject matter jurisdiction on the record, Your Honor.
Not addressing that.
He has asked that
further than
over
I've
and over
addressed
again.
already, sir. There's a written decision. I remind you of that.
And that written decision, did I receive, well, actually, I didn't receive anything. Was there copies made?
Mr. Brooks, I'm going to ask you one more time. Are you prepared with your closing argument? I'm going to have the jury brought out. There's no other legal arguments I need to address from you at this time.
All right, he keeps raising this argument about subject matter jurisdiction, hence the title of the show. Subject matter jurisdiction. What is subject matter jurisdiction? Let's read that. I had it up. Subject matter jurisdiction. Here's the link so you can follow along. I'm not gonna read. You know what? I'll share the screen. I could always go back to that. It is subject matter jurisdiction. The power of a court to adjudicate a particular type of matter, provide the remedy demanded. Overview. A court must have jurisdiction to enter a valid, enforceable judgment on a claim. Where jurisdiction is lacking, litigants, through various procedural mechanisms, may retroactively challenge the validity of a judgment. Jurisdiction may be broken down into two categories: personal jurisdiction and subject matter jurisdiction. Personal jurisdiction is the requirement that a given court have power over the defendant based on minimum contacts with the forum. So they can get personal jurisdiction by your behavior, what you do in the court, responding. Like him, he's saying they don't have jurisdiction, but yet he's cross-examining witnesses and calling in witnesses, talking about the case. So, and at one time, the judge even said, I have jurisdiction by your own actions, and she's right. Now, if you're gonna claim jurisdiction and then they rolling over it, the best thing you can do, I believe, is to shut up. Remember, this is not legal advice. I'm a minister. I'm administering spiritual advice right now. Shut up. Look at the trial they had Christ on. He didn't say anything. If you're trying to claim jurisdiction and then you start behaving in a way and acting out and responding to questions, there's the jurisdiction. There's that person's jurisdiction. And you also give them subject matter jurisdiction because you're saying that the court can hear the case. Okay? So, let me continue to read. Subject matter jurisdiction is the requirement that a given court have power to hear the specific kind of claim that is brought to that court. While litigating parties may waive personal jurisdiction, they cannot waive subject matter jurisdiction. So what it's saying is subject matter jurisdiction, that particular court, does it have the authority to hear that type of case? The court he's in, it has subject matter jurisdiction because it can hear criminal complaints. That court is set up for those types of issues. So yes, it has subject matter jurisdiction. She said she wrote a judgment. I'd be curious to read what she put down in there. But he keeps challenging that. But at the same time, he's challenging that, and then he's proceeding and behaving as if they have jurisdiction. You see? Hold on, y'all. Stand by. I need to do something. Give me 1 second. Pause for 1 second. I'm going to take a short break. I'll be right back. All right, sorry, y'all. I had to straighten out something here. Had to get rid of some distractions. All right, where was I? All right, so sorry about that. I had some noises going off in the background. I had to shut it down. But subject matter jurisdiction simply is that court the right venue for that type of claim? And that court specifically is uh for that. Now somebody's putting here subject matter jurisdiction can be challenged at any time, at any point. Yeah, so what? Yes, it can, but doesn't mean it's a valid challenge. It doesn't mean it's valid. His claim is not even valid. That subject matter jurisdiction doesn't even apply because the court he's in is designed to hear is the venue for criminal matters. I just read it. Let me go down. General and limited jurisdiction. The requirement that a court have subject matter jurisdiction means that the court can only assume power over a claim which it is authorized to hear under the laws of the jurisdiction. For example, Congress limited the subject matter jurisdiction of the United States tax court to cases related to taxation. So if you had a case in tax court, they only hear tax cases. They don't hear anything else. That's called limited jurisdiction. That court does not have subject matter jurisdiction over any other matter. This is important, most state courts are courts of general jurisdiction, whereas federal courts have limited jurisdiction. That is, state courts are presumed to have power to hear virtually any claim arising under federal or state law, except those falling under the exclusive jurisdiction of the federal courts. So I can't go in, take a tax claim into a state court unless they have the jurisdiction to do so. You see? However, for pragmatic reasons, some states deny subject matter jurisdiction to specific claims, such as those arising in other states. Most states also maintain specialized courts of limited subject matter jurisdiction. Examples of these types of courts include probate courts, traffic courts, juvenile courts, and small claims court. As for federal courts, with few exceptions found in the Constitution itself, Congress defines their limited subject matter jurisdiction. In order to bring an action in federal court, the plaintiff must find a constitutional or congressional grant of subject matter jurisdiction to allow the federal court to hear the claim. You know what's interesting? Whenever I go over these topics, it's always the so-called know-it-alls that got, oh, you could do this and you do that. But when I asked it, like I said in the beginning, when I asked for proof of what you're saying, you never show me. And here's the thing. Anybody in my chat offering their opinion without backing it up with facts, you're out of here. I don't have time to sit up here and have you spew your opinions. Especially most of the people that spew their opinions never spent a day in court ever. They're listening in different groups, people saying what they can and cannot do. For instance, case in point, this 1099A craze that people are going on doing for the last year with no proof of anybody being funded with anything. Now the channels that talk about it ain't even talking about it anymore. Why? It's like I said, it was going to fall through. Soon they're going to switch to other topics. Now they're talking about rights to travel and stuff like that. They barely talking about the stuff that got them all of their followers now. When are y'all gonna see? When are y'all people gonna stop getting taken by these shysters? These people who, and I think let me rephrase that. Some of these people, a lot of these people are shysters, but some of these people get into this and they genuinely want to help, but unfortunately they don't do their real. They tell you to do your research, do your research, but they haven't researched themselves because their research is based on someone else telling them what the truth is. Not what they read as rule of law. That's the level of their their knowledge. You see? Here it is. Here, extrinsic fraud. Here's this. See, this is the stuff. Extrinsic fraud can cause a court to lose subject matter jurisdiction. See, this is all of these so-called information. These people, they give you these points without giving the foundation of what they're talking about. This case ain't about fraud. This guy. There's nothing fraud. He drove through a crowd, whether he did it deliberately or he was out of his mind. I don't know. I wasn't in his head. All I know is he took a vehicle and drove over some people and harmed them. And they need to be made whole. Partly, they can never be fully made whole because people lost their lives. See, the only recourse they have is for the state to prosecute him and send him to prison. If they sue him, they got a civil complaint. They can go lodge against him, but will they get any money? He's broke. He doesn't have anything he can give these people as way of restitution. So the only thing that's available for remedy is prison time. That's it. The court can lose you. Okay. All right, let me move on. So let's go back to the video. Where was I? Oh, here it is. Here we go.
I'm informed of what you're saying. I was merely asking, was there copies made of you said written decision?
Sir, my written decision has been filed into the record. That is done electronically. You were provided with a written copy previously. Are you asking for another copy of that, sir?
Yeah, I don't have it.
As a courtesy, I'll have my clerk print off a copy and provide that to you.
Is it proven subject matter jurisdiction?
Your objection to the lack of jurisdiction has been noted repeatedly on the record.
Can't question jurisdiction and
It is a
participate at the
meritless
same
argument.
time. Remember that.
I've indicated that in my written decision as to why there is subject matter jurisdiction, and I will continue forward with the final stages of this trial, which I hope include your closing argument and the final instructions to the
This
jury.
been going on all day, 8 hours, 9
Prove
hours.
subject matter jurisdiction on the record too.
All right, I will instruct the jury to come out. For the record, the written decision is once again being provided to the
I accept
defendant.
for value and return for value this document, as it is not based in lawful law, and it does not prove subject matter jurisdiction.
What is he talking about? Lawful law.
Refers to some complaint.
She look frustrated as hell. Like
The name of a trust,
Well,
not my name. Were you aware
now
of
he's
that?
talking about the trust.
Mr. Brooks, the jury has been asked to be brought out. I mean, I've requested that they be brought out. They're on their way.
Were you
Please
aware of
be
that?
prepared with your closing argument.
Were you aware?
Just imagine if you was related to one of the victims who died in this, and this guy is talking about a trust. You would be furious, because you wouldn't know what he's talking about. And people have brought this trust up in court, talked about it, did all of that stuff over and over again. I mean, I've seen people do it in traffic cases, in child support cases, and, civil cases. Never seen it used quite this way before. And if it didn't work in those cases, what makes you think it's going to work in this case, in a murder case? Those other cases, no victim, right? There's victims here. It's insane. It's insanity. And this is the result of these years of people doing seminars teaching this nonsense, doing videos teaching this, and people who are not using their right mind are following this stuff.
Or is that a tacit agreement that you don't have to answer any questions?
Tacit agreement. I've heard that one before.
All right.
So that is a tacit agreement.
Record to reflect the jury is coming out.
He's standing up. He's doing everything like as if he wants to.
Thank you, everyone. Please be seated. Go ahead, sir. You may begin your closing argument.
I'm not ready to begin closing arguments.
So this is your opportunity to provide your closing argument to the jury. Please start. I've started the timer of 1 hour.
I'm informed of that, Your Honor, but I'm not ready to proceed as I don't understand the
now he's using the don't understand tactic.
The jury was present and were not answered. There are issues that needed to be addressed outside of the jury, as you always say, which I don't understand why the jury deserves.
Mr. Brooks, this is your opportunity to present your closing argument to the jury. Please do so.
I'm informed of that, but the jury needs to understand the truth, their rights, and their duties, as they have not been informed of their truth, their rights, and their duties.
Mr. Brooks, the court has begun the instruction process. I read 73 pages this morning, and into the early afternoon, I have another 30 plus pages to read. They will be informed of the law.
Did you inform them that they can nullify the law?
Mr. Brooks,
I told my jury
you do not have that right to request that. And I'm
they
advising you one more time, this is your opportunity to provide your closing argument. Please begin.
I intend to when ready. I just want to know if the jury was informed that they can nullify the law.
Mr. Brooks, you have the right to make that argument to the jury.
No,
It's true.
Okay,
They have
okay. He's looking for them to nullify the law. They have the power to do it. But let me ask you a question. Why would they do that? Why would they nullify the law? What reason would they have to nullify it? What's the purpose of nullifying? Like, why would they do that for him? I mean, it comes to a point where you guys start using some type of common sense, which I don't think he has. Or maybe he's just acting out of desperation. He's talking about nullify the law.
power.
All right, I'm going to excuse the jury.
They should know that they have the power.
Please rise for the jury.
Just imagine, man. Get a family member sit behind this guy. Stuff like this make you do it. Should I be going to parades? Should I? Like, you know, you go to a parade. Let's skip ahead.
Sir,
You said I couldn't instruct them.
the jury
on
has
that.
the power, but not the right to nullify.
Right. You said the power. You said the
Listen to
power.
me, sir. You're interrupting me once again.
So I'm going to inform them that they have the power.
Are you telling me, sir,
I'm
that
not
you are
telling you no
going to
such thing. I just
disregard
told you what you just
my
said.
directive to you to not raise the issue of jury nullification during your closing argument?
That's not what I said. You just read and said that they have the power to. That's what you just said.
Let me see if I can get that.
State versus Bejerkus says,
Let's go here.
forward with the final stages of this trial. which I hope include your closing argument and then the final instructions to the jury.
I would hope it proves subject matter jurisdiction on the record too.
All right, I will instruct the jury to come out. For the record, the written decision is once again being provided to the
I accept
defendant.
for value and return for value this document as it is not based in lawful law. And
It's kind of hard to move. I can do with that. Since it's still live, I think it's kind of hard to move back and forth between the frames.
Thank you, everyone. Please be seated. Go ahead, sir. You may begin your closing argument.
I'm not ready to begin closing arguments.
So this is your opportunity to provide your closing argument to the jury. Please start. I've started the timer of 1 hour.
I'm informed of that, Your Honor, but I'm not ready to proceed as I don't understand the reason why the questions asked before the jury was present were not answered. There are issues that needed to be addressed outside of the jury, as you always say, which I don't understand why the jury deserves to
Mr. Brooks, this is your opportunity to present your closing argument to the jury. Please do so.
I'm informed of that, but the jury needs to understand the truth, their rights, and their duties, as they have not been informed of their truth, their rights, and their duties.
Mr. Brooks, the court has begun the instruction process. I read 73 pages this morning, and into the early afternoon, I have another 30 plus pages to read. They will be informed of the law.
Did you inform them that they
Mr.
can nullify the law?
Mr. Brooks, you do not have that right to request that. And
Were
I'm
they
advising
informed?
you one more time, this is your opportunity to provide your closing argument. Please begin.
I intend to when ready. I just want to know if the jury was informed that they can nullify the law.
Mr.
They
Brooks,
are-
you have
they
the
have
right
the
to
power.
make that argument to the jury.
It's true, they have the power.
All right, I'm going to excuse the jury.
They should know that they have the power.
Please rise for the jury.
I know them jury be like, we going in, we going out. Which one is it? Just that alone is I can almost put money in. They gonna convict him. He is persistent though.
Thank you. Please be seated. Mr. Brooks, you do not have a right to request jury nullification directly from this jury. I direct your attention to the Bajurkas case, BJERKASS, that's State versus 163 Wisconsin 2nd 549. While you are not incorrect that the jury has the power to nullify, they don't have the right to do so, and no party has the right to instruct or to request an instruction or to argue jury nullification. You may talk in terms of fairness in general terms, but you may not go further. You may not argue that the jury should discard the instructions in the law and find you not guilty for that reason. You may
So he's talking about jury nullification. So what is jury nullification? Let's talk about that. Let me show you what that is. This is jury nullification. Jury nullification refers to a jury's knowing and deliberate rejection of the evidence or refusal to apply the law, either because the jury wants to send a message about some social issue that is larger than the case itself, or because the result dictated by law is contrary to the jury's sense of justice, morality, or fairness. Essentially, with jury nullification, the jury returns a not guilty verdict, even if jurors believe beyond a reasonable doubt that the defendant broke the law. This can occur because a not guilty verdict cannot be overturned, and jurors are protected regardless of their verdicts. So he's looking for them to nullify, do it, just give him a win in a murder trial, which that's highly unlikely. There are differing perspectives on the role and basis of jury nullification in American jurisprudence. Some view jury nullification as a right, but there are examples of people being punished for disseminating the information. For instance, 2 people passed out pamphlets about jury nullification in Colorado and were later arrested and charged with jury tampering. Indeed, jury nullification is technically a discretionary act and is not a legally sanctioned function of the jury. As such, jury nullification is considered to be inconsistent with the jury's duty to return a verdict based solely on the law and the facts of the case. And counsel is not permitted to present the concept of jury nullification to the jury. So, in some cases, he could be charged with a crime, is basically what they're saying, if he tells them that they have that power. However, there is a historical basis for jury nullification. Its origin is seen where juries in colonial America used jury nullification to protest the British by acquitting defendants. There are other historical examples as well. For instance, in the 1800s, Congress passed the Fugitive Slave Clause, which compelled citizens of all states to assist law enforcement with the apprehension of suspected runaway slaves. Some abolitionists used the jury system to protest and refuse to convict people under these laws. This was also seen with prohibition laws. States also defer on jury nullification. In California, Judge Jan Goldsmith requested an opinion about jury nullification related to the case Sparf versus United States, in which the decision was that the California trial jury did not have the right to refuse to apply the law. The Supreme Court case Kleinman versus United States confirmed this sentiment. So now you understand what that means, what he's talking about. But that is highly unlikely that they're going to do that for him. Why would they do that for him? Why? Why would they do it? Let's continue.
May not use the phrase jury nullification. You've done that now at least 3 times in earshot of the jury. Twice while you were in the other courtroom, I was able to mute half of what you said the second time, and then of course you raised that once again while in front of the jury just now. You also indicated you weren't ready to give your closing argument. Sir, the time has come for you to give your closing argument. If you choose not to do so at this time, then you will forfeit your right to present a closing argument by your conduct.
I haven't made any such choice. So you can't coerce me into a constitutional right waiver when I have not waived the constitutional right. And I will not allow you as a public servant to do that. I have not made a choice.
Sir, the time has come for you to present your closing argument.
Are you making a judicial determination that you're denying me a constitutional right in open court?
I have not made such a determination as of yet, but you can forfeit your constitutional rights
under
by
what
conduct.
law?
Illinois versus Allen, State versus Anthony.
Illinois versus Allen does not reference anything pertaining to rights when talking about
in
closing
State versus
statements.
Anthony,
Illinois
the Supreme
versus
Court
Allen.
of Wisconsin referenced both that decision when it essentially extended the reasoning or adopted the reasoning of Illinois versus Allen to then find that a defendant could forfeit an important constitutional right by conduct. In State versus Anthony, it was not the right to be present in the courtroom, it was the right to testify.
Okay, so none of those that you just named have anything to do with the closing arguments, Your Honor. You've used Illinois versus Allen repeatedly to when it comes to me being removed from the courtroom. Not one time did it bring up anything dealing with a closing statement or a closing argument. So how's that same statute being used for something that it doesn't even refer to or pertain to.
Mr. Brooks, the Allen decision, Illinois versus Allen, and the Anthony decision, which is State versus Anthony, are two examples of cases where a defendant lost a very important constitutional right because that right was forfeited by the conduct of that particular defendant.
And that was to be present in trial, correct?
The right to present a closing argument is no different. Because it is not evidence, it could be said that it doesn't even rank as high as the right to testify, which is guaranteed by the constitutions.
Which I was denied the
I'm
right
not prepared to
be
make
able
that
to
ruling
testify
here
to.
yet today, but I will tell you this, sir. The time has now come for you to present a closing argument. There will be no further delays. I will not be taking any further adjournments for you to prepare. You were advised yesterday that this court would proceed today with instructing the jury and with the parties making their closing arguments.
And you made that while violating my constitutional right.
Sir, please don't interrupt me because you've now interrupted me a couple of times.
No, once. So let's make that correct. Once.
That's the third time.
Okay, now you can say
so. So, Mr. Brooks, I'm advising you yet again. The time has.
He's just
informed the jury of their power. Again, I never stated that.
This is for it. We all know the defendant in his petulance will say jury nullification in the first 3 seconds the jury's in the room.
Objection to that.
Proper thing to do, I think, Your Honor.
Stop interrupting.
I don't think I should be talked down to.
Allow him to make his closing arguments. I will object if he misstates the law. You can instruct the jury to disregard
my opening statements.
He giving closing statements. I just wanted to show this part.
A well-prepared or rehearsed speech.
Oh, stop this nonsense.
I didn't look in the mirror and say certain points to myself over and over again to make sure I have them right.
Here's the problem. He claiming all his jurisdiction, but he's giving closing statement. Yeah. You know, I won't even play it. I'll give y'all the link. Y'all can watch it in your free time because it's so painful to watch. It's crazy. So painful. This guy, something is definitely not right in his head. Either it's desperation or insanity, one or the other. So, see, King Bay says, it makes me cringe to watch this dude. He is lost. Definitely. He's lost. And he's lost partly because he's getting bad advice from people. He's not reading the rules. Jury nullification, you can't bring that up to the jury. Not as him representing himself. If he had an attorney, the attorney couldn't bring that up because that's what prejudicing the jury. You trying to sway them. And you know you can disregard all of this evidence of me driving over these people and just rule in my favor. That's what he's actually asking these people to do. It's clear he was driving that vehicle. It's clear. I mean, if you watch the hours of stuff, it's clear he did it. And he, in so many ways, admitted to it that he did it. Somebody said they could tell him where he got that mess from. Oh, yeah, I can tell you where he got it from. I know. I've heard it over and over and over and over. I got caught out there believing that stuff 7 years ago till I tried it and got my ass handed to me in court. I said, never again. So that's what made me study the rules. And that's how I come out with victories because I study the rules. I would never go into the courtroom. First of all, I wouldn't be in that position he's in, but and start spewing that nonsense. Whenever I was in a court for a traffic, I didn't say hardly anything. I didn't do all of that arguing back and forth with the judge and all of that stuff. You don't have to. If you have put proper motions into place, you put your proper filings in place that make sense, you get respect. He trying, yeah. How do you know what his motives are? Someone saying he mistrial is the motive. That's what he's trying to do. Maybe it is, maybe it isn't. He gonna get convicted. I can tell you that much. He getting convicted. You see, and I think the judge is the one who's got to say a mistrial, call it a mistrial. So that's not happening. They're doing closing statements. They're going to send that jury out there. They're going to deliberate, and they're going to come back with a big, big, big guilty. And his actions, if think about it, you're sitting here watching this guy, you as a jury, you formed an opinion on him in the first 10 minutes he started this technique or this tactic. I hope y'all get y'all. I hope y'all paying attention because this is not the way to behave in the courtroom. It's not following all this, accept it for value. I accept this for value. He's done that. I've seen him do that at least 10 times. I accept this for value. Use my exemption. Yelling that out. I know other people that try to write instruments and put them into cases, and all it did was make their problems worse. It baffles my mind that people are willing to risk their freedom and their life with techniques they hear from people in YouTube. I tell y'all, don't believe nothing I say. Go, here's where I got it from. Like I read all of these, what was subject matter jurisdiction? I go to there and I read it to you. I read it word for word. I didn't add any words. I didn't paraphrase. Most of these people out here teaching y'all stuff will never, ever open up the law and show you what they're talking about. What they will do is they'll go reference somebody's website who's commentating on this stuff. They'll repeat what someone said, but they will never go to the law and match their words to what the law says. Never do. Everything I promote or teach, I can take you to the rules and show you what you can and can't do. That's why I tell y'all, go get that software. If you don't want to use a lawyer, go get that software. You win without a lawyer. That is an actual attorney with years of experience, double-digit years. I think it's like almost 30 years of experience teaching you how to go into court, teaching you the rules, not these what they call sovereign citizen techniques. Go in there, go take it. It's only $250 for the year, and it's $89 to renew it every year. I've had that software since 20, I want to say 17. I've been renewing it every year. Why? Because it's an investment. And the reason why I renew it, because I always have to refer back to make sure that I'm on point with what I'm doing. I don't rely on YouTube gurus to give me all of my information. I know I got a YouTube channel and I'm showing y'all, but I'm pointing y'all where to go get real information from. Truthful information. Not stuff that's going to get you in any trouble. See? That's the link if you want to look at that trial. You want to go and look at it and see him make a fool of himself. I think he would have been better off. You hit these people just working out a private resolution instead of going through 3 weeks of this trial, going back and forth and trying to discharge a murder charge. He talking about constitutional rights, but what about the rights of the people he took? He took their right to life. Hypocritical. He took their right to live, but he wants someone to respect his rights at a trial in constitutional. It's mind-boggling, y'all. And this is the kind of nonsense that sets us back or makes us look bad as a people. This type of behavior here. And when you look at, he was already out on bail on some other violent crimes that he had committed. So in a way, the state is needs to take some responsibility there. This guy had a long history of violence. He was even registered as a sex offender. And he had some stuff where he shot at his nephew, pulled a gun on his nephew, something. I don't know if he shot or he did shoot, and he was out on bail on that. It was still pending. You know, COVID happened a couple of years ago. COVID happened, and he was released on a very low bail. And this goes to show you how when COVID hit, they was letting a lot of violent criminals out. What were they trying to do? Were they trying to cause anarchy? Cause problems? Because he got out, and within months later, he got out early, part of 2021. Later on that year, November, this is what happened. So I believe the state need to look at that too. You know, if I was a family, I'd be suing. You ain't gonna get no money out of him. I'll try to go to the next best thing. Hey, you guys let this guy loose with a violent past. He had pulled a gun, firearm on someone, shot at a family member. Come on. You know? All right, it's 8:07. I think I talked about this craziness enough. Listen, if y'all wanna really win these things, you wanna do good, go study the law. If you don't like attorneys, that's fine. Go study it. You can win without a lawyer. I have. I've seen other people win, but you know how they won? They studied the rules and did follow proper court procedures, and they won. I was telling the group last night, one of my young ladies, she's probably got 3 or 4 consultations. She was wanting to sue debt collectors. This started off like at the beginning of the summer, maybe towards the end of spring. And she asked me, what to do. I told her, okay, this is what you need to do. Get that software. And then I gave her what I know from the software, what she needed to do. She filed a claim. I said, you file a claim against these debt collectors, more than likely they're going to settle with you because they don't want to take that to trial. We're talking about $1,100 debt. They're not going to, and you're going to ask for a jury trial by jury, not jury trial by jury. They're going to call you up and ask for a number. What can we give you to make this go away? Do you understand these corporations already have money set aside for settlements? That's in their budgets already. Think about the power you have against these corporations. Think about that. It's not about, when you understand how this thing, it's not about who's right or wrong. It's all about who pulls that first punch. You file a complaint against them because they contacted you about a debt, whether you created the debt or not. The third-party debt collector laws are clear. They need your express permission. You contact them, and then you file a suit against them. They're going to settle. The debt was $1,100. She asked for $10,000. They settled at $3,000. Not only didn't have to give the $1,100, but she get $3,000 for it. $3,000. Now, if everybody took that power and went after all of these so-called debt collectors, he would shut the debt. A lot of y'all wouldn't have a lot of these collections on your credit report. Just taking that simple knowledge right there. Okay, you want to come at me and bother me? I didn't ask you. Let me sue you for this. And y'all get money. I'm telling you, a lot of y'all have money on your credit report. Y'all have at least This is just one claim. She had others. One claim, $3,000 settlement. Y'all, some of y'all at least have that. One, at least that. Y'all talking about y'all ain't got no money when y'all sitting. Y'all got money on your credit report right now that y'all can make. All it takes is learning, knowing how to prepare a complaint, get it served properly. I think her whole investment with the complaint was around not even $200. Ain't that's a nice little come up? Under $200 and make $3,000. Now, I'll tell y'all this. If it was me and I was going after a debt collector, I wouldn't go at them in my individual capacity. I would go at them in my trust. My trust would sue them. And then have that check made out to my trust. Acting on behalf of me, the beneficiary of the trust. Yeah. That's how I would go at it. See, things hold a lot more weight when an entity is suing another entity. And she did it as an individual. And the reason why I say that, they're going to write the check in her name. And you got tax implications and all of that stuff when you get the money in her name. But if you get it in your trust, it's a whole different ball game. And I'm going to shut up on that one. All right, y'all. It's 8:13. That's it for me tonight. Y'all saw this trial. Don't go in there doing your accepted for values. Take that. If you were planning on doing an accepted for value exemption stuff, take that over to the trash and dump it. Okay? That's just my advice. Here we go with the legal. These are administrative hearings. They are not court. So what? These administrative courts giving real consequences like he's about to see. See, these are the arguments I keep hearing. They're not this. They're not this. Okay, what does that mean? Since they're not this, what are you going to do about it? Where's your proof that you've won anything? You know they're administrative courts. What's the purpose of your statements? What you going to do with that? There's one thing to say something, what something is. The other things, what are going to be the results of you knowing that information? I can put money on it. You don't even know what to do with that. Are you making that comment? They're administrative courts. You never even spew that information out. Oh, they're administrative. They're this, they're that. No. All I need to know is the rules of court. Is there evidence? That's all I need to know. I don't give a damn what type of court it is. I just need to know the rules. And in those rules, just like me sitting down playing a game of chess with somebody or checkers or whatever, all I need to know is the rules. I don't need to know, is this administrative checkers game? What kind of? No, I just need to know the rules of checkers. That's it. Or chess. See, here we go with the dumbness. I'll just see. This is when I start blocking the nonsense. I ain't even gonna put that up there. Told y'all coming in with y'all spewing y'all legal theories and all of that stuff without offering proof. Because the stuff this dude was just saying was stuff he heard in seminars. He heard on YouTube. He heard from other people. All right. Peace, prosperity, and extreme wealth to all. I am out. Peace. Till next week. Or maybe sometime later this week. Who knows?
I can hear the demons call when they do what they do.